This is Headnotes, a podcast from Whitehead Moncton. Coming up on this episode.
Whether you're a small family-run business or you're a large corporation, there is something in this Act that will definitely affect the way your business is run and how your business should approach managing employees.
Looking very much like the widest changes to employment law, I think it's fair to say that, without wanting to scaremonger, I think the upshot of most of these changes is that there will be a greater risk of claims or certainly contentious matters arising. Hello and welcome to our Headnotes podcast. Today, my name is Antonio Fletcher. I'm head of the employment team here at Whitehead Moncton, and I'm joined by Eloise Jones, who's one of the solicitors in the employment team. We're here to discuss the Employment Rights Act 2025, which has recently come into law. Looking very much like the widest changes to employment law that there have been in a generation, in 30 years since the Employment Rights Act back in 1996. Lots of the changes are happening over the course of this year and into 2027, albeit we've had a few that have crept in already. The first of which was back in December when the minimum service rules around trade union activity were repealed, having fairly recently been introduced by the old Conservative government. And then also in mid-February, a few rules around taking industrial action and reducing notification requirements and those sorts of things that are there to help make union action a bit easier and smoother, as was always the case with the new government's plans. Or, well, we call them new, but they're not that new anymore.
To be fair, I think on that point, Antonio, what we're seeing is a lot of widespread trade union changes that are coming into phases. So the Employment Rights Act, we're seeing sort of 5 major phases throughout, starting in December from 2025 to 2027. And sort of trade union seems to be a common theme amongst all these phases.
Drip fed, yeah.
Yes, but I think whether you're a business or an industry that's affected by trade unions or not, there are so many other aspects of employment law that have been majorly changed by this legislation. And whether you're a small family-run business or you're a large corporation, there is something in this Act that will definitely affect the way your business is run and how your business should approach managing employees. So I think it's vital for employers to get to grips with it now and make proactive steps towards all of these changes.
Yeah, absolutely, because the range of changes that are being put forward are so wide. I mean, we've touched on the points around trade union and actually even for those businesses and organisations that aren't unionised at the moment, I think the one note to bear in mind is the changes probably make it that much more likely that in future you may get a knock on the door from either one of your employees or one of the unions trying to get recognition. But we're going all the way from those sorts of things to some sort of fairly basic rights and family-friendly rights that will affect employees in organisations large and small. So there's something for everyone, as you would say, and doubtless they'll bring additional challenges to employers that they need to be prepared for. Certainly. There's work to be done on things like contracts, policies, handbooks that really need looking at now and at a very early stage. We've also generally started saying to clients that actually it's a really good time to start looking at the training your managers have and sort of making sure that they've got suitable skills to manage people as well.
Yeah, I think that's a great foundation to sort of lay upon everything really here that are coming into place. As as if management and key members of your staff and HR don't understand these changes and how they will impact the way that they interact with staff and the policies that are going to be coming into place and the changes, then ultimately your workplace won't have a good grip on the changes coming in. So training is fundamental, as well as you said about amending handbooks and policies and such. And I think it's going to be, not a quick journey, and it's definitely going to be one that takes time and a costly exercise. But comparing that towards, potential claims for tribunal claims and other processes there, it could save your business money in the long run for sure.
Yeah. I think it's fair to say that, without wanting to scaremonger, but I think the upshot of most of these changes is that there will be a greater risk of claims or certainly contentious matters arising. I think that probably leads us quite neatly onto probably what was, if you like, the headline grabber for quite some time, although it's been somewhat diluted, and that's the day one unfair dismissal rights.
Yes, I mean, it was Labour's big ticket item. It certainly garnered the most controversy as this bill was going through Parliament. And we have now moved from having, the employee has to have 2 years of qualifying period down to just 6 months. So, some would argue better than the day one that Labour was pushing for. So employers still have this 6-month period. But sort of how do you see this sort of impacting businesses having that sort of reduction from that 2 years?
It's a significant shift. I mean, I've been practicing in employment law for about 20 years now, and 6 months is significantly less than anything we've had before as a qualifying period. Sort of remember back in my days of early qualification, there was a year's service was required. And even that felt a bit tight for some roles. I always particularly remember sales roles and things like that where there were capability issues, but the capability issues weren't really evidenced until the first year's figures came through, and people got cut a bit of slack, but then things didn't improve in year two, and by then people already had qualifying service. Now you change that from a year to 6 months, and that really is a short amount of time to make a judgment on someone and think, are they the right fit? Do they have the right skills to fit our business and our role, the role we're looking to fill? And actually, you take the view that nowadays, actually, most probationary periods are only 6 months in duration. I think there's an argument now with that shorter qualifying service to think about shortening probationary periods back down to, I think it's fair to say, actually, a few decades ago, 3 months was quite a typical probationary period. It might be worth looking back at doing that and just making sure that period in time is very closely monitored and effectively so, and that people, a manager who has an employee coming into their business, a new employee coming into their business, that actually they very much treat those initial months as a priority of making sure that they're the right fit, rather than sometimes as people get busier and things like that, a lot of managers get caught up in the day job rather than effectively managing teams, and that's really something that can't be afforded nowadays. And nor can poor recruitment decisions. I think that's really key now, is that actually you're bringing the right people in from day one, because there's not too much scope to get that wrong without then having to potentially go through lengthy processes to undo the mistake.
Yeah, no, definitely. And I think the job market is going to see a big change in sort of having these more tightened recruitment processes, maybe a lot more stages in interviews, and employers taking it very seriously instead of going, some may have just, let's just take a chance on this candidate, and how that will affect people, maybe new graduates, people who are, changing careers. I think there may be some impact there, but certainly businesses will be looking to tighten this up, and also, managing properly, and instead of saying, this person, they'll just pick it up soon, give them a few more months.
Yeah.
We really don't have that sort of timescale anymore. So properly reviewing someone's performance, giving them feedback on where to improve, and seeing if that change can happen, I think will be really, really sort of appropriate here, and sort of taking into account, the statutory minimum for notice periods, at least by the 5-month mark, making that decision on whether that person will stay within the business or not. So you can avoid going into, over the 6 months and having to think, if this person isn't working out, you have to have a really fair reason and look at conduct, capability, and give those reasons to them to make sure you're following a fair procedure, and making sure that procedure is up to date to align with this, I think will be really important.
Yeah, absolutely. That's when we talk about having unfair dismissal rights, that's what we're talking about, really. In order to dismiss someone fairly in law, you need to have a fair reason, and there's recognised reasons like capability and conduct and redundancy and things like that. But there's also a need to follow a fair process. Now, that could be following, a process akin to the ACAS code in a misconduct situation. That could be following a fair redundancy procedure in redundancy situations as well. So it's quite onerous. And when you look at things like, for example, capability, a performance-related dismissal, generally in a probationary period where someone has short service, if they're not performing and it's recognised they're not performing, it's really quite easy. People tend to get called into meetings and are given, often only a week's notice, and they leave. In circumstances where you've got unfair dismissal rights, then the situation is very different, in that actually you can't just dismiss someone for not being up to the task. You have to give them the opportunity to improve. It becomes, potentially a lengthy process lasting several months to get to the point where it's fair to dismiss them. I think the other point I just flag in terms of when we're talking about this change coming into effect, then it looks very much as if it will be the 1st of January 2027. Now, that could result in actually lots of shorter serving employees being exited towards the end of this calendar year to avoid those rights if they don't feel like the right fit. Hopefully that won't be the case, and people will be looking at implementing the sort of the good management and the good recruitment processes before then. But that could have a particular little spike heading towards the tail end of this year.
And adding on to that, we're also looking at sort of the 1st January 2027. The cap for compensation is going to be abolished for unfair dismissal as well. Yeah. So currently, the compensation for an unfair dismissal, the compensation award, is capped at either 52 weeks gross salary or the statutory cap, which is around 118,000, whichever is lower. We're going to be seeing the removal of that alongside of this. So it is a higher risk for employers as well. So not only do you want to not go over that 6 months and then not manage the process fairly, you have to realise that there's a higher risk at the tribunal for this higher award as well. So all the better to get it right now.
Yeah, absolutely. And it looked like actually the removal of the cap was subject to quite a lot of debate, whether that was just a mistake or something that had been thrown in to avoid the cap of people's salary. If let's say a lower earner had losses going beyond 52 weeks, but actually it's a removal of the cap altogether. So it's actually going to increase the risk, particularly with high earning individuals, people that might be earning sort of over 118,000 a year. Actually, suddenly the unfair dismissal doesn't look that much different from a whistleblowing or a discrimination claim in terms of the potential awards that people could get. So that's certainly going to be a concern, I think, to employers. I suppose beyond the changes to the unfair dismissal service, there's quite a few other things, quite a few other major changes amongst what's being announced, and we're going to have separate podcasts on the unfair dismissal point, but also on a few of these other topics as well. One that strikes me as perhaps going under the radar a little bit is actually from October this year, there's going to be an increased time limit to bring claims in the tribunal. Most claims, there's a couple of examples, a couple of exceptions, around breach of contract claims and things like that. But the majority of claims will have an increased period in which someone can issue a claim from 3 months to 6. Now, the way the government's presented this is that it will give parties more opportunity to settle disputes before they actually end up in tribunal. I'm not sure it's going to work out that way, to be perfectly honest.
No, it seems, increasing this limitation window, and many think, 3 months to 6 months, that's not really a great deal of time. But when you're actually in sort of the dispute itself, it can seem like ages, really. And increasing this time window for a claimant to, bring their claim could, balloon tribunal claims that we're seeing at the moment, and sort of the concerns about, I know it used to encourage to, settling tribunal claims before they reach there, but it will also open up more tribunal claims to go through to the tribunal. Yep. So there's a lot of concern about how much strain the tribunal can take, especially even currently, it's not doing that great at the moment. So how much support the government is going to lend to sort of backing this up and backing up ACAS as well, and the strain on their services. We'll just have to something we wait to see, really.
Yeah, I mean, certainly there's a big question mark, I think, over tribunal resource to manage additional claims. I think we're sort of seeing listings of about 18 months to 2 years in our local tribunal after the issuing of the claim, which is not really how the tribunal was ever designed to operate. It was supposed to be a fairly quick, less formal way of getting matters resolved compared to the court system, and it's far from that at the moment. So an increase in claims would cause problems. Equally, I think my big question mark would be, even if we allow this extra time to try and settle, for example, are ACAS going to be able to provide a meaningful service in terms of helping to settle in those times? I think ACAS at the moment is one service that is also somewhat overrun, and it's quite difficult in pre-claim conciliation to get much meaningful assistance from ACAS, to be blunt, at this point in time, and I'm not sure whether they're going to be able to deal with yet more claims coming their way as well.
Yeah, I think it's whether they're saying, it's, exactly what we said about the ACAS, and sort of whether they're going to provide meaningful sort of, that sort of mediation going in between and helping facilitate those conversations between the employer and the employee. Whether or not that's going to be the basis of these settlements, or whether parties are going to be so put off the length of time and the delays in the tribunal that it will just deter them and sort of force them to, want to settle it quicker. Yeah. I think either way we'll have to see what kind of pushes towards these higher settlements. Yeah.
But yeah, keep a lookout for another podcast that we'll be doing on that particular subject and the wider implications of this change. We've also got changes in the pipeline to 0 hours workers, 0 hours contracts, trying to give them more certainty, compensation where shifts are cancelled. That will be in 2027 and is, I think, sort of largely formed in terms of its structure, but there'll probably be a few tweaks to that along the way, and clearly a big impact to those who use casual workers and 0 hours contracts workers there as well. We've got the removal of fire and rehire provisions in October this year. That that really is. It's well, let's say fire and rehire. I think probably for the last 3 or 4 years, even with the old government, was getting a lot of negative press, and a lot of moves were being made to distance that as a typical practice. And I think the real trigger from that was the P&O ferries situation, where sort of significant chunks of workforce were dismissed to just be replaced by cheaper labour. So it's had a lot of bad press. It's no surprise to see that there will be tighter restrictions to fire and rehire. But the one consideration that has to be made there is actually, well, what's going to happen in practice if there can't be an agreement between employer and employee about changes that might need to be made to the contract. Now, there are carve-outs in the legislation for very extreme cases where the employer might go under if they don't make the changes, but there's a lot of circumstances sometimes where contracts need varying, and if employees were to dig their heels in, it could make things extremely awkward for all parties without that old get out of the fire and rehire.
Yeah, definitely. And this is only going to come into effect this October, so there isn't a lot of time for a lot of these details to really be ironed out. So I think employers will really, if they definitely hire zero-hour contract workers, and we're talking retail, special seasonal workers, I think it's definitely something to keep an eye on, keep a look at the guidance and sort of the regulations that are going to be coming in, and see how this will actually affect your business.
Yeah, absolutely. A lot of these changes are sort of quite, again, as we said earlier, quite far-reaching. We've also got sort of changes coming into effect around sexual harassment and harassment more generally, third-party harassment in particular. Those coming in October, and actually sort of fairly hot on the heels of changes that were made in October 2024 around sexual harassment, but that are being tightened up further now.
Yeah, so hopefully the employers are all, as they fresh in their minds really from October, with the just taking the reasonable steps to prevent harassment, sexual harassment there. And now from October 2026, we're looking to say it must take all reasonable steps. So a lot of employers may be wondering what the definition of all is, and that is still being worked out, and more guidance will be coming out about that soon. But especially from what we've learned from, what are the reasonable steps in the first place, we're looking at such things as training, policies, what you can put in place, and especially with this new limb of the, third-party harassment as well. Taking a risk assessment of your business and seeing who your employees interact with, whether that's suppliers, contractors, or members of the general public, seeing where the risks are and how you can mitigate those the best you can, and taking all the steps you can, whether that's signage or clauses in contracts with third parties as well to make it clear, and just creating an overall very safe working culture, which ultimately will benefit all, let alone in these, circumstances where harassment could take place.
Yeah, absolutely. I mean, there's so many implications of falling foul of those requirements, and the uppings of the standards required of employers, if you like, is it is going to make life more difficult for employers, but it is so important reputationally, but also in terms of claims and having a reputation as a good employer, and being able to attract people into your business. It's so important that employers are very much on top of those sexual harassment changes. And again, that's something we'll be doing a separate podcast on, so look out for that. Just looking now really at some of the changes that are coming more imminently in April this year. There's quite a few that do have a certain knock-on effect here and there. First of all, we've got a day one right to paternity leave, so no necessary qualifying service required anymore. It's not the most attractive
No.
form of family-friendly leave. I think it's one where we're pointed at as being a bit behind certainly some other sort of European nations, given that it's a very low rate of pay that people qualify for during paternity leave. And the other door that's been open is to day one unpaid parental leave. And again, it all goes, it's all in the name of it being unpaid. It's a nice thing to have and have the right to, but not many people can actually really afford to make the most of it.
No, definitely not.
Because if you're missing salary to prioritise your family in certain circumstances, it's a difficult decision to make, because actually ultimately it may act to the family's detriment in other ways of not having that income coming in. So that's one of the family-friendly rights that's on the horizon, but it'd be nice to see, I think. I think most people wouldn't argue against a bit more generosity in the statutory entitlements in those areas. We've also got changes to statutory sick pay that are quite interesting ones. So at the moment, people earning below a very low threshold have not been entitled to claim for statutory sick pay on days that they're on sick leave. And everyone has had to wait until the fourth day of sickness absence before statutory sick pay kicked in. Now, with these changes from April, statutory sick pay will apply from day one, and it will apply to everyone regardless of what they earn. So it opens a few doors there.
Definitely. I think it's one of the sort of biggest changes for statutory sick pay in years, really. The government have sort of conducted some consultations and reviews of how this will impact businesses, and it's looking to impact around £15 per employee. So if we're looking at the overall UK business market, it's about £450 million, which can seem an awful lot, and people are quick to dismiss this as a very costly and onerous burden for the employer, and that is true in some aspects. But the aim is to sort of curb, people going into work unwell, and they may not be as productive, and they may make other members of your team sick. And overall, this presenteeism costs businesses a lot more than this absenteeism that we're seeing. So encouraging those to take the time that they need and take that one day off work to recover, instead of forcing themselves to go in and potentially making themselves more unwell, could actually see a benefit for the business. And that's where the government's intention lies with this. And I guess we'll just see, 1.3 million were currently within this lower earnings limit, and they will now have access to that as well. So I think, it'll be a big change to this area, but one that we hope will, be actual benefit to a business.
Yeah. I think that's right. I think that there's a tendency to perhaps look at the introduction of statutory sick pay from day one to, in a negative way from an employer's perspective, and say, oh, will it lead to more short-term absence? Well, actually, I think the points you make about presenteeism, about actually taking time away when, you might be contagious with an illness and that could wipe out many of your colleagues for a few days as well. So I do actually see it as a positive myself. We've just going back to the subject of sexual harassment. One of the key changes in April is that sexual harassment will be recognised as a reason to give someone whistleblower protection. Now, I'm not sure in practice whether that's going to actually change a lot, because arguably if someone does make a disclosure about sexual harassment, they're already covered under the limbs of whistleblower protection as they stand. But actually what it does is it highlights, again, the importance of sexual harassment and preventing sexual harassment in the workplace by explicitly giving people that extra protection. So hopefully that will be a positive change again. And then we've got things like where we're talking about collective redundancies. If anyone were looking to make 20 or more redundancies, the importance of actually going through a proper collective consultation process is heightened by the fact that actually the penalty for not doing so has doubled, or will double, from April, from 90 to 100 days pay, to 180 days pay. So that's a significant shift upwards.
Definitely, and employers will now have to focus on the redundancies across their whole organisation, and it's no longer limited to just looking at individual workplaces. So there's a lot of consideration. So whether you've got a business and they've got a branch in Kent, or they've got one up in Birmingham or other places, to not just take a tunnel vision to each place and see the overall impact, because as you said, the award has gone up and there's a greater risk of getting it wrong. Yeah,
absolutely. So any employers looking at sort of making those larger redundancies across their business need to be very well aware of that. We've also got a new sort of institution being introduced in April called the Fair Work Agency. Now, it seems like they're taking little bits of work off other institutions here and there, from HMRC, etc., and they will be looking at things like enforcement of minimum wage, holiday pay, statutory sick pay, and things like that, and playing a role in seeking to remove those discrepancies from the workplace.
Yeah, I think it's quite an interesting sort of, he says, fragments of different departments, and this comes under the Department for Business and Trade. And it's looking to take a more proactive approach towards businesses. So doing sort of inspections to make sure that all of your policies and procedures are in place and you're treating your workers fairly and you're covering all of these changes here. It's very different to the reactive approach that we've been seeing all these years of investigations only happening after reports coming to light. So it's definitely really interesting, and it's just putting the pressure on employers to, keep accurate records, keep your policies up to date, and make sure you're following the changes, because you don't have to wait for a tribunal claim to be triggered or someone reporting this. You can just have an inspection. So that's why you need to get on top of things now.
Yeah. And then a couple of other changes, perhaps less headline grabbing, that are in April, but further drip feeding of the union changes. So the requirement for a 50% turnout for votes on action will be removed from April. And then we've also got voluntary gender pay gap and menopause action plans being published by employers with over 250 staff. And that will become mandatory for them from 2027. Yeah,
so if it's voluntary now, then definitely recommend businesses, get on top of that now, because it will become mandatory anyway. So at least give yourself time to prepare those action plans and reports as well. And, there will be penalties for failing to comply with this. So as soon as the better, really.
Yeah, exactly. It's sort of, it's, if you can, I suppose the message would be publish now, because again, it sets out a strong message for your organisation if you're publishing those voluntarily and not just being seen to do it because you have to when they become mandatory next year. Good point there. And then just to round off, we're just going to touch on a few of the family-friendly rights. We've mentioned a couple of those that are coming in April. But certainly things further along the line, and I think a key one really is additional protection for pregnant women and new mothers from dismissal, not only during pregnancy and maternity leave, but also for a period of time. It's likely going to be about 6 months after their return to work, that will make any dismissal automatically unfair, save for a few very limited exceptions that you can see being sort of extreme cases of gross misconduct and things like that. But that's a significant level of protection for pregnant employees and those returning.
Yeah, definitely. And so this will be taking effect in 2027, and we are still waiting full details on the regulations. There's a lot of guidance. Of course, it's quite a wide area, as it covers not only just, maternity leave, but it also covers the neonatal care, bereaved partners paternity leave as well. So, and it ties in quite nicely with the bereavement leave that's coming in as well. So there's currently no statutory right to bereavement leave unless your child dies under the age of 18 or you're stillborn after 24 weeks. But we're going to see a big change from that from 2027. So it will be a day one right of at least 1 week of bereavement leave. Regulations are still to specify the relationship that they will have. But it'll likely follow, definitions we've seen in the past with dependents. To have that sort of connection there, and it will include the pregnancy loss under 24 weeks as well. So we do see a overall strengthening of these family-friendly rights going forward, and this will be unpaid, unlike parental bereavement leave. So as we said with paternity leave earlier, it's not exactly where it needs to be compared to other countries, but it is a step towards the correct direction, and hopefully it gains more momentum as it goes. But definitely sort of a big one for those who are starting families or, considering families there.
Yeah. And, again, sort of potential some shifting on flexible working rights and things like that, that are all encouraging noises, I think, for families and people with dependents generally, that we may see in the months and years ahead. And certainly the discussion I've heard several times from sort of members of the government is that in some respects this is only the start, particularly in relation to family friendly rights, that they do want to see a lot more come in. So it will be good to see how that progresses in the months and years ahead.
Definitely. I think there's such a wide range of topics that the legislation touches upon. Some major changes, some minor changes, and it all seems to be things that have been coming out past recent years and decades that people have been actioning for, wanting action on. And it's now coming to fruition. And it's just a game of, preparing your workplace to get these all in place. And then we'll see, and the government's, pledged to keep consultations, keep doing impact assessments on how this is affecting the UK businesses and the economy, and just see how that they can adapt that going forward and see which ones they can, push even further in the upcoming years.
Brilliant. All that remains to say is thank you for joining us today. Do keep an eye out for further podcasts, as I said, and also events that we're running, some seminars and webinars on the topics associated with these changes. Thanks very much.
Thank you.